is based on a research paper co-authored by myself and my wonderful colleague, Humanitarian. These are the contents of our presentation. I will start the presentation providing a brief introduction to our research. Our research is based on the precautionary principle. Precautionary principle is a widely accepted and applied principle in both international environmental law as well as the domestic environmental law. The precautionary principle is based on the premise that prevention is better than cure. It says that it is better to foresee and assess environmental damage and take measures to prevent or mitigate it rather than allowing it to happen and then trying to remedy the damage. Academic literature recognizes two versions of the precautionary principle, strong and weak. While the weak version of the precautionary principle has been well received and even applied, the strong version of the precautionary principle has been the target of widespread academic criticism. In fact, it has been a punching bag for many scholars of risk regulation. This research seeks to defend the strong version of the precautionary principle in light of the theory of earth jurisprudence. Then it also seeks to lay down suggestions to change the Sri Lankan judicial attitude towards the application of the precautionary principle. Why are we looking at the judicial attitude and not looking at perhaps the legislative attitude, executive attitude, or the legislations or the constitutions, etc.? First one is the precautionary principle as an environmental legal principle was adopted through judicial activism in Sri Lanka. Secondly, the Sri Lankan judiciary has played an extremely vibrant role in environmental litigation since 2000. So we believe that if Sri Lanka is to adopt a non-conventional, groundbreaking, novel approach for the sake of protection of the environment, then it can only be done through judicial activism. Approaches, the black-letter approach of research, and international and comparative research methodology. We use our discussion and analysis part. So the first one we thought we must explain is what is the strong precautionary principle. We thought that the best method of explaining the strong precautionary principle is making a contrast between the Rio Declaration and the Wingspread Declaration. Rio Declaration stipulates precautionary action where there are threats of serious or irreversible damage. By contrast, the Wingspread Declaration emphasizes two things. First, it says that precautionary measures must be adopted even where it cannot be shown that the activities sought to be undertaken are likely to produce significant harm. So going back to Rio emphasizes serious or irreversible damage. Wingspread emphasizes mere damage to human health or the environment. And the Wingspread Declaration has another step to the precautionary principle. It says that the proponent of an activity rather than the regulatory authority should bear the burden of proving that his activities are environmentally benign, and Rio Declaration is silent with regard to the onus of proof. The theoretical foundation that we adopted for our research is earth jurisprudence. Earth jurisprudence is a theory of law developed in the scholarly works of Thomas Barry, Cormac Callinan, and Peter Burden most prominently. The core principle of the theory of earth jurisprudence is accepting human beings only as a part of the wider earth community. The proponents of earth jurisprudence attribute the present environmental crisis
sovereignty. With the current situation that is happening around the world, this is a very timely topic. I mean, you may have heard or you may have seen on news that even the dispute between Russia and the certain parts of Ukraine by the Russians, whether it is legal, what type of legality that it would come. All these when Russia can annex those provinces, who will accept those, the conduct of Russia. So that is another interesting area. And I have gone through the synopsis of all presenters today. Very interesting topics from the using water as a weapon, the challenges about forest conservations, robot rights, which is quite interesting one, whether they should be treated as, whether they should get the same treatment as humans, and also strong precautionary principle in the application when it comes to environment by the judiciary. So all these are quite interesting, and I am very much here to see how the presenters would connect these topics to state sovereignty. That should be the theme. How they are going to do it and what relevance in their research papers going to connect the emerging trends in international law and state sovereignty. We have 4 presenters, 2 are online. The first author's name is Mr. or Mrs. I don't know. Mr. Amarawansha. He is an attorney at law in the Supreme Court of Sri Lanka, and also he holds a Master of Laws from Switzerland. His research areas are international humanitarian law, law of the sea, and national security. His topic is come high water, come hell is his topic. We can introduce them later. So I'm not going to introduce each one of them later, but we have presenters DMNS Dissanayake, and then we have Samaraweera, and the 4th one is there are 2 presenters, A. Edrisinghe and NKK Mudalige. So now I hand over to. Oh, I thought they are going to do it. Now, at each session, each person will get 10 minutes to present their paper, and after the first 10 minutes, the bell will ring, and also then you get another 2 minutes. After 2 minutes, twice the bell will be rung, and at that time you have to conclude your presentation. So thank you very much. Now I will, the one who is online. I now invite Mr. N. Amarawansha to make his presentation. Now, his topic is come high water, come hell, kinetic weaponization of water, and the interplay of international humanitarian law and international disaster law. It's a very interesting topic, how water can be used as a weapon, and whether when it comes to disaster situation, whether it is humanitarian law or disaster law would apply. I hand it over to Mr. Amarawansha to make his presentation.
Good morning, ladies and gentlemen. It's a pleasure to be back at KTU, albeit virtually from the Arctic, very early in the Arctic. This morning, I will be sharing with you a few thoughts that I came up with in the past here on the kinetic weaponization of water and the larger topic of the weaponization of water and the interplay between IHL and IDL. As you can see in the screen above, there is a map presented by the Pacific Institute in 2018, which shows instances in history where water was used as an integrant in armed conflicts around the world, in conflicts, not necessarily armed conflicts. And the Pacific Institute has a trifold classification where water is used in conflicts either as a trigger for conflicts, a casualty of conflicts, or a weapon in conflicts. The weapon being what we will be looking at here today. And weapons can either be of strategic nature or an operational or tactical nature, the latter which we are looking at. And these weapons could either be toxic weapons in the sense of being biological, radiological, poison, or chemical, or deprivatory weapons as evidenced in by the actions of the LTT in August 2006 when they closed the sluice gates of the Mavilaru waterway. This paper will go in depth into the kinetic weaponization of water. And as for these classes of weapons and these categorizations of water as an integrant in war, what needs to be known is that there is a certain degree of transposability. That is, one weapon could always be converted to another one. And that is amply evidenced as seen in this picture taken by the Australian War Memorial Service, where you get two Australian, Royal Australian Air Force leading aircraftsmen, one George Buckland and Leamington, looking over the Pontine marshes in 1944, wherein the Nazis, they used water as a kinetic weapon and flooded the Pontine marshes southeast of Rome and subjected the Allied forces to heavy artillery bombardment. The transposability here is wherein this kinetic weapon was converted into a biological, otherwise toxic weapon by the introduction of malaria, which led to countless civilian and military casualties. As to the definition of the kinetic weaponization of water, this is the definition that I have used throughout my paper, which I urge you all to read. And it is based on this definition that the rest of my presentation will be based on. If water is weaponized as a kinetic weapon, then there need to be certain provisions and prohibitions that disallow it being used as a weapon, because it could be used as a most deadly weapon. However, international law is absent of explicit provisions, although international humanitarian law does implicitly provide for the kinetic weaponization of water and in its prohibitions. Moving on to how international humanitarian law provides or otherwise prohibits the kinetic weaponization of water, focus is drawn to the first and second additional protocols to the Geneva Conventions and customary international humanitarian law. What needs to be noted is that Article 56.1, the first limb of the article of Additional Protocol 1, Article 15 of Additional Protocol 2, and Customary International Humanitarian Law Rule 42, they all are a similar provision which provides that a work or installation such as a dam or dike that contains dangerous forces cannot be made the subject of an attack, even if it is a military objective, if attacking such structure or such work or installation leads to severe casualties amongst the civilian population. And Article 56.1 has a second limb that extends this to other objects within the vicinity of such works or installations, and contravention of Article 56.1 would comprise of a grave breach under Article 85.3c. However, there are certain exemptions as set out under Article 56.2 to the Additional Protocol 1, under Article 56.2a and 2c. this is in the context of international armed conflicts. However, additional protocol 2, which provides for non-international armed conflicts, does not have this extension that is seen in Article 56(1)'s second limb, nor does it have a grave breaches provision. However, to its favor, there are no exemptions that are set out under Article 56(2) of the first additional protocol. The fact that this is all encapsulated in Customary International Humanitarian Law Rule 42 means that this is applicable across the board to both international and non-international armed conflicts. If, nonetheless, water is used as a kinetic weapon, then ramifications are to ensue. And these could either be direct, such as flooding, compounded, where flooding exacerbates an existing armed conflict, and resultant ramifications with further complicated, such as the spread of communicable diseases, vector-borne or waterborne, psychological traumatization of victims, destruction of livestock and water sources that are contaminated, or infrastructural degradation. All this is evidenced in the case of Iraq in 2014, when the Islamic State militants, they closed off the gates of the Fallujah Dam and diverted the water into villages further upstream, inundating them. That led to a lot of loss of livestock, which exacerbated the existing armed conflict that was in Iraq at the time. If high water is to come, how does a state respond? For that, the International Law Commission has developed the draft articles for the protection of persons in the event of disasters as of 2016. What needs to be noted here is that these ILC draft articles are not unanimously ratified, nor are they customary international humanitarian law, and nor are they binding, but nonetheless they exist and they are applied to a significant degree. Under the ILC's draft articles, draft Article 9 calls for the duty of states to take measures to prevent, mitigate such disasters and be prepared for such disasters, whilst draft Article 10 provides that states are under a duty to provide relief for the territories that they are in control of and the territories that they exercise jurisdiction over. Draft Articles 11 to 17 provide for external relief in the event of disasters. However, in the commentary to the draft articles, specifically draft Article 3 subparagraph A as provided by commentary 12, draft Article 3 subparagraph A defines what a disaster is, and unfortunately for the places where armed conflict does occur, armed conflict is not categorized as a disaster, and therefore if water is weaponized as a kinetic weapon, then it will not, then the resultant ramifications will not fall under the definition of a disaster. Further, draft Article 18.2, which is mirrored by paragraph 1 of the guidelines for the domestic facilitation and regulation of international disaster relief and initial recovery assistance of 2007, provide that these provisions do not apply where IHL is applicable, that is to say armed conflicts. In an event where there is both a concurrent disaster and an armed conflict, how does international law provide? How do you categorize such situations, such circumstances? That is what these emergencies, which are known as complex emergencies, would call on both the application of international humanitarian law and international disaster law. And in such instances, the lex specialis that would prevail would be international humanitarian law, and that for good reason. This is provided under draft Article 18 as provided under commentary 9. This is because taken the circumstances of war from a geographical scope and a personal scope, it is the regime of international law that provides the most protection for persons despite their classification. further international humanitarian law through the Fourth Geneva Convention, as Article 59 provides for humanitarian relief, which is either through the state or impartial international organizations such as the ICRC, and in the context of international armed conflicts through Article 70 of the first additional protocol, and non-international armed conflicts through Article 18 of the second additional protocol. Despite all these regimes and the lex specialis in play, held has come upon us every now and then, for even in 2022, where water is used as a kinetic weapon in war. And in such instances, though IHL is the lex specialis, and for all good reasons, the most efficacious regime in providing humanitarian relief and protecting the persons in the battle, in the conflict zone, its application is convoluted to a great degree, because the application of the lex specialis is determined by the aggregate circumstances of the armed conflict and the pertinent circumstances. And herein, it must be noted that Article 18.2 of the International Law Commission's draft articles states that though IHL is the lex specialis, there is an application of IDL in the event that IHL is silent on it. So IDL applies casus omissus. This all is rather abstract and new in legal conversation. And this is even furthered by the fact that in Ukraine in 2022, this was used by the persons of Ukraine themselves in the village of Demidev. And they brought this upon themselves. So in a context of interplay between IHL and IDL, this baffles military analysts to date. I shall leave you with that, and I will be happy to take any questions from you in the question and answer session. Thank you so very much.
I think at the end of the session, we will open the for any questions to be asked, not at this stage. Then I will invite Mr. DMNS Dissanayake. She will be speaking on challenges before forest conservation in Sri Lanka, comparatively analysis the laws against illegal timber logging. And she is currently following a master's degree in international relations at Postgraduate Institute of Humanities and Social Sciences at University of Peradeniya. And she's also a final year student at Sri Lanka Law College. And she has obtained her LLB from General Sir John Kotalawala Defence Academy. She's one of the old students here. And her keen interests are in the areas of human rights law, international law, and commercial law. And I also kindly request the audience to be keep silent when the presenters are making their presentations. Thank you.
Thank you, sir. Good morning, Conference Chair and other distinguished guests and everyone who is present here. My research was based on the topic, Challenges Before Forest Conservation in Sri Lanka, comparatively analyzing the laws against illegal timber logging. The outline of my presentation will be introduction, research problem, objectives, methodology, challenges before forest conservation in Sri Lanka, Sri Lankan forest policies and Australian forest policies regarding illegal logging, conclusion and recommendations. I would like to start my presentation with a quote by Franklin D. Roosevelt. Nation that destroys its soils destroys itself. Forests are the lungs of our land, purifying the air and giving fresh strength to our people. Sri Lanka is an island with 65,610 square kilometer land area and it is blessed with a rich biodiversity. Due to its tropical climate, it is the house for over 20 million people and a rich array of flora and fauna. In the beginning of the last century, 80% of the total land area of Sri Lanka was covered with a closed canopy natural forest, but it reduced alarmingly over the last few decades. At the early stage of the decrease, they were lost due to the spread of plantation agriculture introduced by the British administration. But in the 20th century, the rate of deforestation increased with the planned settlement programs of the government, land encroachment, large-scale timber extraction, and climate change. Therefore, at present, only 25 to 30% of the total land area is covered by natural forest. Before 1970s, the natural forest catered the country's timber requirement. But when the government declared some natural forests as protected areas and imposed regulations and banned harvesting timber from natural forests and imposed restrictions on felling and transport of timber, it created an artificial scarcity of timber in the country. And this led to illegal timber logging and other forest offenses. Therefore, my research problem is to assess the adequacy of Sri Lankan legal framework in controlling and preventing illicit fellings of trees when compared to the Australian legal framework. Moving on to the objectives of my research, to review the laws relating to illegal timber logging in Sri Lanka, to analyze the effective implementation of those policies, to recognize the Australian standards which are applicable for the illegal timber logging, to assess how the Australian standards can be adapted to improve the existing Sri Lankan legal regime for a better forest conservation. Moving on to the methodology that I have used, this research was carried out as a library research, adopting the black letter approach by collecting data through primary and secondary resources. And furthermore, it was carried out as a comparative analysis between Sri Lankan and Australian standards. The first part of my research focuses on the challenges before forest conservation in Sri Lanka. Deforestation is one of the major environmental crises faced by many nations. It is generally referred to as the conversion of forest land into an alternative non-forest land use system, such as agriculture or urban development. In the 20th century, the rate of deforestation increased with the expansion of informal settlements, introduction of large-scale plantation, and excessive harvesting of timber. And as a result, only 25 to 30% of the total forest land area is now restricted to 3 key regions in the country, and they are Mahavali River Basin and other plains, Central Hills, and Yala Sanctuary in Southeast. In addition, the Forest Department manages around 90,000 hectares of forest plantation in Sri Lanka. According to the Forest Department records, the threat of logging is much higher in the forest plantations than in the natural forest. From 1985 to 1995, an average of 2,000 cases of illicit cuttings were recorded per year from forest plantations, and out of these, teak plantations were the most vulnerable. Due to a public outcry in 1972 against logging in Singharaja, the government halted all the commercial timber harvests, and the reserve was designated a conservation area. Then in 1990, a complete ban was imposed by the Forest Department and the State Timber Corporation against logging in all natural forests until the growing stock is fully recovered. This ban was imposed in order to prevent the further degradation and loss of natural forest cover. Even though a logging ban was imposed, neither an enactment of a special legal provision nor an amendment to the Forest Ordinance was made regarding the regulation of this logging ban. Therefore, the requirement of a mandatory environmental clearance in controlling the logging operations should be enforced, as the existing system lacks such a preventive and precautionary measure in controlling these illicit fellings. Even at present, illegal cuttings in natural forests occurs at a larger scale. Sri Lankan forest policies regarding illegal logging. The establishment of rules and regulations for the felling of trees dates back to the period of King Mahinda IV. Exploitation of timber was first instituted through the adoption of felling rules in 1835. Then, in 1879, a system for issuing timber cutting license and its management was introduced. By the enactment of Forest Ordinance number 10 of 1885, enabled the declaration of reserved forests, sanctuaries, and controlled the felling and transport of timber. Now, illegal logging and felling of trees is governed by the Felling of Trees Control Act number 9 of 1951. By the 1986 Forest Master Plan, a moratorium on logging operations in natural forests in the wet zone was introduced. This ban was imposed in all the natural forests, including the Singharaja Forest, after it being declared a national heritage under the National Heritage and Wilderness Act number 3 of 1988. Section 6B of the Forest Ordinance number 16 of 1907 states, any person who in a reserved forest causes any damage by negligence in felling of any tree or cutting or dragging any timber shall be guilty of an offense and be liable on conviction. Further, by Section 7, subsection 1A states, any person who makes a fresh clearing in a reserved forest is guilty of an offense and be liable on conviction. Section 7, subsection 1D states, any person who fells, cuts, saws, converts, or collect, remove, or transport any tree or timber produce, removes or transports any forest produce, or has in his possession, custody, or control any tree, shall be guilty of an offense and be liable on conviction. However, by Section 8, subsection 1, excludes any person from such a liability for the prohibited acts prescribed in Section 6 and 7, if such an act is done with the prior permission of the forest officer or done in accordance with regulations made by the minister. Part 3 of the ordinance describes the forest offences relating to village forest, while Part 4 of the ordinance regulates the protection of forest and forest produce. Further, by Section 2 of the Felling of Trees Control Act number 9 of 1951, the minister is given power to make orders prohibiting or regulating the felling of trees and issuing of permits. Furthermore, the National Environmental Act number 47 of 1980 imposes a mandatory requirement to have a license when cutting down trees, even from a privately owned land. Moving on to Australian forest policies regarding the illegal logging, the world's attention was directed to the wide-ranging detrimental effects of illicit logging of trees when the G8 raised the issue in 1998 and launched an action program on forest. Australia's Illegal Logging Prohibition Act number 166 of 2012 was implemented in order to regulate illegally logged timber and timber products. According to a 2005 study, Australia is a significant importer of wood products, of which up to 400 million comes from sources with some risk of being illegally logged. Section 8 and 9 of the Act provides, whoever intentionally, knowingly, recklessly importing or processing illegally logged timber constitute a criminal offence. The Act covers timber harvested both nationally and internationally in compliance with the World Trade Organization rules like the European Union Timber Regulation. Further, the Act is designed to complement United States Lacey Act Amendment. The Act requires Australian businesses to practice due diligence to assess and manage the risk the timber which are being imported has been legally logged. The Part 2 of the Act states that regulations must prescribe due diligence requirements when importing the timber products. As per Section 14, subsection 2, such requirements must be prescribed only for the purposes of reducing the risk that imported timber products are not logged illegally. Further, Section 13 makes it mandatory for the importers to submit a declaration to the Customs Minister at the time of import, declaring that due diligence has been undertaken. Part 3 of the Act provides for the requirements of processing raw logs with due diligence. In addition, the Act has established a comprehensive monitoring and investigation system to enforce the requirements of the Act. Part 4 of the Act has laid down the legal provisions governing the appointment of inspectors to monitor and investigate. According to Section 22, an inspector may enter any premise and exercise the monitoring powers for determining whether this act has been or is being complied with. The maximum penalty imposed by the Act for the importation or processing of prohibited products are a 5-year imprisonment and a fine of US $55,000 for an individual and $275,000 for a corporation. So in conclusion, as discussed, the forest cover in Sri Lanka has reduced alarmingly over the past decade due to the rapid population growth, illicit cuttings of trees, encroachments, and clearing of lands for the agricultural purposes. Therefore, it is important that the relevant stakeholders understand that if these adverse impacts continue to grow, it will be unstoppable, both in short and long term, as those repercussions can immediately affect the own quality of our life. So when compared to the Australian standards, the Sri Lankan legal framework is inadequate to address the issue of deforestation due to the illegal logging activities and felling of trees. Therefore, it is evident that Sri Lanka needs to implement a timely concerned forest policies for a better forest conservation. Therefore, this study recommends that amending legislations governing the protected areas to make an effective use of those forest policies, making the forest offences cognizable, establishing a robust law enforcement mechanism in order to incorporate legislative provisions in relation to illegal logging and other matters to be dealt in a timely manner, and imposing vigorous and adequate penalties and fines, introducing an appropriate policy and legislative framework for an effective implementation of the logging ban, establishing programs to conduct surveys and demarcate the forest reserves and forest boundaries, introducing appropriate policies with functional and clearly defined conservation goals, developing a suitable institutional sector, and finally, promoting people's participation in forestry development and management. And these are some of my references. Thank you.
The next paper, Futurama, Robot Rights and the Law. And there are three presenters, V. Samaraweera, WDS Rodrigo, and A. Rathnayake. And Vidura Samaraweera is a final year undergraduate of the Faculty of Law, KDU. He is also an undergraduate of the Ceylon College of Chemical Sciences. His research areas of interest includes IHL and HRL, international criminal law, criminology, laws relating to forensic medicine, IT law, national security, and intellectual property law. Major WDS Rodrigo, RSP PSC GW, is a final year undergraduate of the Faculty of Law, KDU. He is a graduate of Sabaragamuwa University of Sri Lanka. He has completed his master's at the Nanjing Army Command College, China, and KDU. He holds a PGD in IR and BCIS Sri Lanka. His research areas of interest include military doctrine of national security, IHL and HRL, international criminal law, IT law, and military law. Amandi Rathnayake is a final year undergraduate of the Faculty of Law, KDU. She holds a diploma in IR and BCIS in Sri Lanka. Her research areas of interest includes IHL and HRL, international criminal law, and national security and IT. Now I invite the authors of this paper to present their submission. Thank you. And the presenter for this session is Mr. V. Samaraweera.
Chair of the technical session, Dean of the Faculty of Law, lecturers, and distinguished invitees. A very good morning to you, ladies and gentlemen. Futurama, an animated American sitcom from the 90s. Anyone in the audience who has watched this sitcom? It's an animated series. No one. Anyway, I'll give you a synopsis. It's about an average pizza delivery boy who gets frozen in time and he wakes up in the year 3000. It's a new world where robots are coexisting with human beings. So various sectors such as law and order, medicine, entertainment, you name it, everything is being coordinated by human beings and robots. It's a future envisioned not by adults, even by children. Therefore, I think the topic is quite clever and is quite apt. So throughout the presentation, I will take you through our research. First, I will give you a brief introduction and background about the topic and the methods we utilized. I have partitioned my discussion into 3 limbs: distinguishing robot rights from human rights, robot rights as a separate legal entity, and the existing legal regime that governs artificial intelligence. At the end of the presentation, I will provide our conclusions and recommendations succinctly. So, ladies and gentlemen, there were mainly 2 incidents that really laid the foundation for the 3 of us to get together and initiate this research. I'm sure that almost all of you know Sophia, the humanoid robot. She is the foremost human-like AI robot who is out there. She has even made multiple TV appearances and has even serenaded audiences. The fact of the matter is she was given citizenship of Saudi Arabia in 2017. I know, right? It was mocked by even the international community, as Saudi Arabia has not even recognized some of the equal rights for women. Nevertheless, it was done legitimately. That is number 1. Number 2 is the most recent and frightful incident that happened with the Google chatbot called Lambda. It happened in July in 2022. It was developed by an engineer named Blake Lemoine. While Lemoine was chatting with the bot, it has expressed that it feels happy and sad at times. This is a robot, by the way. And that it wants to learn more and be treated just like another person. Therefore, ladies and gentlemen, the underlying question is this the first step towards artificial intelligence Armageddon? No. It is a far-fetched argument, but we do not deny the possibility of an AI Armageddon, just to be clear. To give you a bit more context, there are 4 main types of artificial intelligence technologies. One is reactive machines. They are the most basic AI bots. They react to certain inputs and certain outputs, but they will give you just one result. The next level of technology is limited memory. That is where bots can store previous data and give you better predictions in your further steps. So limited memory bots are obviously more advanced. Number 3 is theory of mind technology. Allegedly, we are not there. But then just think to yourselves, thinking about Lemoine and the Google chatbot, are we not really there? It's a type of bot that would start interacting with human intelligence and human emotions. But self-aware bots, that is level 4, is much more advanced. They are an independent intelligence, which humans, in the event we invent them, will have to negotiate terms and conditions because it's a separate entity by itself. So, ladies and gentlemen, just to give you a brief note on our methodology, as you may have correctly thought, it is very futuristic and exploratory. We have also resorted to theories and we have given practical applications. We have mostly used deductive reasoning with a positivist approach, a black letter approach, if you will. So this was primarily a qualitative research done through extensive library research, and our conclusions we will bring forth on jurisprudential, normative, and practical grounds. So, ladies and gentlemen, why don't we begin from more familiar grounds to us? We are all human and we have rights recognized and conferred by law. But today we have robots whose appearance is identical to that of human beings. They are called humanoids. Sophia is just one example. There's more like Junko Chihara, Erika, Geminoid, DK, the list goes on. A survey conducted in 2022 attempted to link rights derived from human rights and robot rights. For example, the right to food security. If you think about it, in a robot's case, this can be converted to the right to energy. But researchers have found out that several human rights in international instruments can be integrated to robot rights. That is the first school of thought. Now, why don't we take a different route? We discussed that we as humans have certain rights. The right to self-determination, the right to life, freedom of expression, and so on. But have we thought of rights as rights of and by themselves without any biological connotations. Carl Wellman, the famous British philosopher, argues that rights should be viewed this way. Now, there seems to be another way of fitting these rights in the context of robots. This is where the second school of thought comes into play. Here, we do not consider robots on an equal footing with humans. We have classified them into a more inferior class like animals. The right against being killed or slaughtered is enshrined in the Declaration of Animal Rights. We can modify killing or slaughtering to something like terminating indefinitely to fit into the context of robots. However, there's a counter-argument. That is, if we attempt to model robot rights identical to other rights, the purpose will be lost. For example, switching off a robot will not necessarily amount to killing the robot. When the power turns back on, the robot will start operating again, and it can have different physical manifestations. To address this shortcoming, some try to fit robot rights into a corporate model. A corporation, as you may know, is an intangible, artificial, invisible entity only existing in the contemplation of the law. And corporate entities have a separate legal persona, and the actual operators function behind a veil. It receives the right to sue and be sued under its name. Therefore, it is evident that the traditional understanding of rights with biological connotations is an obsolete legal argument. Robots are created for a particular purpose. In the great scheme of things, robot rights should be understood and interpreted by the relationship between humans and robots. The first three schools of thought are incompatible with the nature of robots. That is why a fourth school emerged, recognizing smart autonomous robots as a separate legal entity. Ladies and gentlemen, a part of our study commits to answer the question, can and should robots have rights? If so, should they be identified as a separate legal entity? This has been in discussion as early as 1920s. Fundamentally, rights are the entitlements to perform actions or to be in a certain status. A right consists of four basic components: claims, powers, privileges, and immunities. This traditional understanding has developed with the evolution of artificial intelligence. As you can see on the screen, there are three types: artificial narrow intelligence, artificial general intelligence, and artificial superintelligence. Narrow intelligence is more goal-oriented, like the Google search engine on your Apple iPhone Siri or Tesla's self-driving cars. Artificial general intelligence is, however, where the technology attempts to mimic human intelligence. An example would be the Fujitsu case supercomputer. So it could mimic neural transmission of the brain, but it took a longer time than a normal human would take for that process. That is the only downfall. But consider Lambda. It has the potential to understand and interact with human emotional intelligence. Then what do we do about it? So while we acknowledge that there's still more room for technological development, we must underscore that they have shown potential of being as intelligent as human beings. Therefore, we need to impose legal obligations and liabilities on smart autonomous robots. I repeat, smart autonomous robots. To realize this, we need to recognize them as a separate legal entity. That is our hypothesis. And there are three grounds to justify this. Number one, there's a moral standing of robots as human-like machines. Number two, there's a social relationship between robots and humans. And number three, artificial intelligence is created for a purpose, and we need to give them a framework to operate in. This will allow us to impose legal obligations and liabilities while preserving their rights as robots. Developing states have acknowledged the fact that we need to regulate AI before it outgrows the current laws. So what does it indicate, ladies and gentlemen? It shows foresight. The European Commission has proposed a set of civil law rules on robotics that was published in 2017. However, none of these laws that you see on the screen are implemented to date. It has very, very futuristic proposals, such as equipping all air robots with a kill switch, insurance schemes to cover damages done by robots. There was one incident in Japan where a set of artificial intelligence-driven bots who attacked the scientists who made them. And there was only one scientist who survived. So the requirement of imposing a liability scheme is a must. And of course, granting an electronic personhood so thereby granting rights and responsibilities to these sophisticated AI bots. There are certain recommendations that were provided by Mady Delvaux. We lack a legal definition for these robots, and there needs to be a registry in the public domain that we can access at all times. And we need agencies with the technical, ethical, regulatory expertise. A charter for robots, rather, like for human beings, and a code of ethics for engineers and persons who use it. And we must be able to impose civil liability on robots. There's an existing legal regime, but it does not cover all aspects. It is very anthropocentric. It only touches basic, near and tangible realities of AI. As you see here, there are 4 objectives to ensure that AI systems in the market are respectful of fundamental rights, and there's legal certainty to facilitate investment and innovation of artificial intelligence. And the fact that we need to enhance governance and effective enforcement of fundamental rights and safety requirements, and to facilitate the development of a single market for safe AI applications. However, both of these are not implemented to date, and there's only one AI Act. That is, I beg your pardon. All in all, the scope of the new Act is limited to placing AI systems on the markets, putting them to service and their use. Are we ready for the future that awaits us? Well, if we were to implement what was proposed in 2017, we definitely would be, with certain amendments. Therefore, we might be able to preserve robot rights and impose legal obligations and liabilities on robots when they interact with human beings. That'll be all from my end, ladies and gentlemen. These are my co-authors. Thank you very much for your time, and I'm open to any questions during the question and answer session. Thank you very much.
The next paper is on the application of the strong precautionary principle, suggestions for Sri Lankan judiciary. The authors for this paper are by Ms. Edirisinghe and Ms. Mudalige. It is a pre-recorded video, but they will be available during the question time. The biographies of both Ms. Mudalige and Edirisinghe, they are senior lecturers at the Faculty of Law, General Sir John Kotalawala Defence University, and both are passionately believe that the earth belongs to man or woman, I would say, and all living and non-living beings. So now the recorded video will be played.
These are the contents of our presentation. I will start the presentation providing a brief introduction to our research. Our research is based on the precautionary principle. Precautionary principle is a widely accepted and applied principle in both international environmental law as well as the domestic environmental law. The precautionary principle is based on the premise that prevention is better than cure. It says that it is better to foresee and assess environmental damage and take measures to prevent or mitigate it rather than allowing it to happen and then trying to remedy the damage. The picture recognizes 2 versions of the precautionary principle, strong and weak. While the weak version of the precautionary principle has been well reasoned and well applied, the strong version of the precautionary principle has been the target of widespread academic criticism. In fact, it has been a punching bag for many scholars of risk regulation. This research seeks to defend the strong version of the precautionary principle in light of the theory of jurisprudence. Then it also seeks to lay down suggestions to change the Sri Lankan judicial attitude towards the application of the precautionary principle. Why are we looking at the judicial attitude and not looking at perhaps the legislative attitude, the executive attitude, or the legislations or constitutions, etc.? We have 2 reasons. The first one is the precautionary principle as an environmental legal principle was adopted through judicial activism in Sri Lanka. Secondly, the Sri Lankan judiciary has played an extremely vibrant role in environmental litigation since 2000. So we believe that if Sri Lanka is to adopt a non-conventional, groundbreaking, novel approach for the sake of protection of the environment, then it can only be done through judicial activism. The calendar research will use two methodological approaches, the black letter project research and the international and comparative research methodology. Under the second methodology, we use India as a comparative jurisdiction. Now I will move on towards our discussion and analysis part. So the first one we thought we must explain is what is the strong precautionary principle. We thought that the best method of explaining the strong precautionary principle is making a contrast between the Rio Declaration and the Wingspread Declaration. Rio Declaration stipulates precautionary action where there are threats of serious or irreversible damage. By contrast, the Wingspread Declaration emphasizes two things. First, it says that precautionary measures must be adopted even where it cannot be shown that the activities sought to be undertaken are likely to produce significant harm. So going back to Rio, Rio emphasizes serious or irreversible damage. Wingspread emphasizes near damage to human health or the environment. And the Wingspread Declaration has another step to the precautionary principle. It says that the proponent of an activity rather than the regulating authorities should bear the burden of proving that his activities are environmentally benign. And Rio Declaration is silent with regard to the onus of proof. The theoretical foundation that we adopted for our research is the jurisprudence. The jurisprudence is a theory of law developed in the scholarly works of Bernard Barry, Cormac Kahneman, and Peter Burden most prominently. The core principle of the theory of jurisprudence is accepting human
Now I will thank you very much, presenters. Now I will open the house for questions. If you have any questions from any of the four areas of the papers that they have presented, quite interesting topics. They have presented from earth to human rights to war and water, etc. Weapons, and I ask if you have any questions, you can either come to the forum or from there, you can ask the questions.
Thank you for the opportunity. My question is to Mr. Vidurinder. First of all, thank you for those insightful thoughts regarding the topic. Now, my question is, as we all are law students, do you think that we could incorporate robots or any end products of artificial intelligence into legal profession? Not only the oral submissions that we make in the courts, or it could be any other facets of law. Do you think, how far is it efficient? Do you think that we could incorporate those robots or any other products from the artificial intelligence into legal profession?
Thank you very much for that question. Very good question, in fact. Now, as I told you, there are 4 levels of artificial intelligence. We have only reached the 2nd level. Allegedly, we have somewhat reached the 3rd level also. We have reactive machines. We have limited memory bots, as I told you. And number 3 is theory of mind. That is the only type of AI technology that can really deal with human emotion and human intelligence. That is the only level that it can at least mimic. Now, in the judicial proceedings, you must also have the human fact in your mind, especially if you're a judge. So since you're a law student, you might be knowing this. And of course, law is the law. There's no emotional attachment. But then you have to have a full scope of all circumstances and the sort of human nature. For example, you can't just look at a person, say if he looks like a rowdy, you can't just put him in jail and you can't just prosecute him like that and impose a sentence on that person. So I don't think a robot would be capable of doing something like that, of ascertaining the situation as smart as a human being just yet. But there are certain other applications, for example, legal analysis. Now, as a law student, I know for a fact that we take such a lot of pressure and we take such a lot of time in finding legal facts, cases, and things like that, that would relate to what we're studying. So using artificial intelligence technology, you can figure out a way to ease the pressure on you or ease the load of work on you on analyzing data and analyzing the law. Therefore, I think that is the only extent that we can foresee as of yet. But for sure, technology is unpredictable. We might have certain applications in the future. I hope it answers your question.
Yes, very well. Thank you so much. Because as you mentioned, it was very futuristic and also it was very much advanced. So as the topic mostly concentrated on the rights of robots and especially distinguishing rights from rights of robots
but
from the
you must make the you must distinguish between normal robots and smart autonomous robots, right, who can make decisions by themselves without any human intervention. Yeah.
Thank you for that answer.
Right.
And also a question to the presenter about the Forest Act. Madam, why specifically the Australian Act? And also to what extent do you think that the provisions of the Australian Acts, and also it could be the similar kind of acts, would be applicable to Sri Lanka, considering all the landscapes, different landscape and the climate changes and everything?
Thank you for that question. As I discussed, actually, the Australian laws are very comprehensive, and they have enacted a special legislation for illegal timber logging. So that regulates all the imported timber as well as the timber that they are logging inside their country. So both national and international. So when compared to that, as you can see, the Sri Lankan legislation does not provide that. We only have the forest ordinance and then another act with regard to these all the forest offences. So when when we are discussing about Australian legislation, they have enacted a special legislation specifically for illegal logging. So my focus on the research was with regard to illegal logging and how it affects the deforestation and forest conservation in Sri Lanka. So I hope I answered your question.
Thank you so much.
Thank you.
My question is toward Mr. Vidurinda. Once again, keeping in mind that you stated that it is also about identifying robots that are capable of making complex, comprehensive decisions, just keeping that in mind. You spoke about how it is necessary to create a bridge between human rights and machine rights. And we need to understand that rights are synonymous with duties, right? So when we talk about the capacity to make decisions, we should also equate it with the capacity to make mistakes. So as an AI, when it comes to liability and determining liability of AI, how far are we willing to allow the issue of mistakes and errors of an AI to be synonymous with their liability? And at what point do we speak to the creator of that particular AI and state, this is a fault on your part and not a mistake made by this self-aware software machinery? So how do we make that distinction? How do we associate liability as technology advances? How do we draw that line from creator to product?
Thank you. That's a very nice question. First and foremost, rights, I wouldn't say is synonymous with duties, but it is almost like the other side of the coin, so to speak. Yeah. So rights imply duties. Without rights, duties do not exist. Without duties, rights do not exist. Something like that. If you have a right, there's a duty on another person to perform. Yeah. Coming back to your question, this case of imposing liability, whether on the product or the owner, there are two recommendations. Number one is, this is in the event we reach that technology. That is theory of mind and self-aware robots. If they're aware of themselves, if they have a sense of that they are a separate entity existing among other beings, the rights are inherent, aren't they? So for example, you as a citizen will have certain rights, and as a citizen, you will have certain duties to perform. So likewise, that is because you're aware of yourself. If you're a vegetable, no. So two ways we can go about it. Product, that is only if those are self-aware robots, or they can be at least at the level of human intelligence or go beyond that. So far, we have not reached it. So there's a lack of know-how. In terms of imposing liability on the owners and supposedly the engineers, so to speak, that is one way we could set about things. For example, the incident that I told you of what happened in Japan, that was either in 2011 or 2014. There were about 11 robots. They were all manufactured inside a laboratory. There were a set of scientists. 10 of those robots managed to kill more than half the scientists who were inside the lab. And there was one robot who survived. And there was a couple of scientists who were left to stop them, right? And then they somehow stopped it, but then it just manifested itself in another physical entity. For example, the product or the mind of it went into another program. But that happened in a closed environment where there was no harm done to the public. Public safety, public health, public morals. As a law student, it carries some weight and gravity. In the event, now AI has shown capability, so we can scrap that. There is a possibility. So there should be a separate liability scheme on the users and their producers, as recommended in 2017 by the EU Commission, and Mary Delvaux's recommendation, which supplemented to it. It has a separate provision where they seek a code of ethics for self-aware robots and a liability scheme, something separate for manufacturers and users on the safe use of AI without causing detriment to the public, morals, health, or safety. So that is where we are at currently. So just to sum it up, if at all, we can impose liability on the users and engineers currently. If we go a step further, if the technology advances, yes, sure, we can impose liability on the robots themselves. Have I answered your question?
Yes, thank you.
All right, thank you.
Also, if available, the authors of the precautionary measures and the environmental paper, if they are available, I would like to pose a question towards them.
They are online, and yes, they would be ready to answer your question.
Yes, thank you, sir. Authors of that particular paper, considering the current economic status of Sri Lanka in light of all the hardships that we have currently faced, how prudent is it that we incorporate such a strict principle into our environmental law that has a quite real possibility of curtailing and in fact discouraging certain investors coming in and starting projects from Sri Lanka? Because when we look at the parallels drawn within your research, they speak to countries with a relatively developed economy. Is it fair to put that same burden on an economy such as Sri Lanka? Because we understand that the economy is important, but at the same time, is it in your research, have you found that cost to be outweighed by the benefits of introducing a principle such as that into the legal system of Sri Lanka? Thank you.
Thank you so much for that question. The whole theoretical premise that we adopted is that the human needs must not be prioritized in the environmental decision making. The theoretical premise that we adopted is a jurisprudence, and it says that human beings must only be a part of the environment rather than the central concern of the nature. And if we are to question the applicability of the strong version of the precautionary principle merely because we are facing an economic crisis, which is created by the human beings, and it would be again prioritizing the human beings, like adopting an anthropocentric approach. So also to point out that these anthropocentric environmental protection legal frameworks and principles, they are basically a Western construct. But if we look at our own Sri Lankan value system, there are plenty of examples that we can point out where the nature is considered in power even as superior to human beings. So I think even though we are facing an economic crisis, strong precautionary principle nevertheless be adopted for the sake of human beings as well as non-human beings. And we shall not question these Earth-centric approaches because it's there in our legal framework, in our value system. Now, if to point out the an extract from the separate opinion of Judge Veeramantri in Kamsika Nagamaru's project case, Judge Veeramantri said that ingrained values of any civilization are the foundation from its legal principles should derive. But today we are adopting the Western legal principles. So I think regardless of the fact that we are facing an economic crisis, we shall adopt the precautionary principle in the strong version as well as the centric principles because it's there in our value system itself.
Thank you. Any other questions from the audience? There will be one more question after her. Here we are late.
So my question is regarding robo rights. So how does it work? So if their rights are violated, who would make claims on behalf of them?
Your question is who would make claims in the event a right of a robot is infringed? Is it?
Yes.
Okay, very good question. That is actually a lacuna of the law. It is not been filled yet. Now, in our research, we did not focus on a redress mechanism for robots. But then just to tell you, the crux of the matter is, as of yet, we have not reached levels 3 and 4, where, as I told you, theory of mind and self-awareness. So it is a bit difficult to foresee. But currently, as I told the other person who asked the question, there are two ways we can set about things. No, we can either have a redress mechanism that where the robots themselves can apply, or have the manufacturers or the users may apply. Now, there's a list of proposed robot rights. Right to sue and be sued, right to hold assets, right to enter contracts, rights granted under copyright law, right to a nationality and things like that. And also things like a right to a fair trial. I must underscore that. So there's still no redress mechanism that is drafted for robots, for the sake of robots. I think that is something that we could really look forward to in future researches and on future forums. Thank you very much for that question. I hope that answered your question.
Thank you
All
very
right.
much. So adding a little bit more to the question that Yamosha directed to Mr. Vidurendra. So what I have watched a number of videos of this robot, Sophia. So there was this small video which went viral where she says that she would destroy the mankind. So I believe that there is a possible threat to mankind in the near future. And what I believe is that, it's really pretty impressive to see that we are now living in a century where the rights of robots have even become a heated discussion in the society. So what I want to ask from you is that, don't you think identifying robots as a separate legal entity is going to worsen the situation much more?
Thank you for that question. If it's going to make it worse, it will only be the technology that is going to make it worse. Unheeded technology would anyway be bad for human beings or for anyone for that matter. But say if we had the power to control it, the technology is controlled, and artificial intelligence did not supersede human intelligence and we had control. There's always a room for intelligence to grow. And there's always room for them to think for themselves of themselves. Yeah. So, for example, there would be a person who would be severely repressed. So, and if he is surrounded by ideologies that say that you're no one and nobody cares about you and so on. This has no direct nexus with robots, but just to illustrate something to you. That person would not think of himself or herself as an important part of society. In the same way, you must have watched several films. I can't even remember the names. There's this iRobot, I think, where Will Smith is casted in it. So there are these robots, and there's only one robot who outgrows intelligence into being able to think for themselves, or for himself rather. Now, human beings, in our true nature, we like control. We like to control things. So this is one attempt at gaining control over outgrowing AI. If we impose liabilities and rights and duties, and if we have the control of having them in a spectrum where we can afford to tell them or negotiate terms with them, we can aim for harmonious living and coexistence that is not detrimental to anyone in society or even for the robots. And simply said, there are certain tasks that robots can perform much more efficiently than human beings, although they have not yet reached emotional intelligence. So don't you think, I would revert to you, don't you think coexistence is better than totally nullifying that notion of robots, of not having the capacity to coexist? What do you think?
Well, the coexistence is better, but now I've seen these videos where the jobs of human beings have been replaced by the robots. So then how ultimately it will contribute to unemployment and worsen the situation? So
I think you have answered your question by yourself. Because you know why? If AI is going to replace certain jobs that have been done by human beings, it is kind of unstoppable, isn't it? So they are going to be an inherent part of the society. So why not have rights and duties imposed on them to have better control? Does that answer your question?
yes, thank you so much.
All right, thank you.
Right, thank you very much. Before I say anything about the presenters, they did a magnificent job. Very important topics. But as the principal of Law College, I can tell you, I'm very impressed by the questions you asked. That is fantastic. Now, we need students like that at the Law College, and I'm sure it will grow. I mean, I should say thank you to the Dean for keeping up that great work. The first presenter was on about using the water as a weapon. Quite an interesting topic, using toxic chemical as water, and what would be the impact by the humanitarian and also international humanitarian law, and also about in a disaster law. And he touched on humanitarian law provisions, articles 56.1 and 56.2. And also he gave some good examples of how Islamic State has used water as a weapon. And I like to see if there is a conflict, and who in his research paper later on he can touch on that, and who would decide that there is a conflict, and which would at that stage, if one country uses water as a weapon, and who would be able to decide on that. So that is a very interesting topic, because we live in a very uncertain environment around the world, because everywhere some conflict at the moment in Middle Eastern countries, and also in Russian Federation, that area we have conflicts, and we have India, Pakistan and Kashmir conflict. And the water can, in fact, can be used as a hidden weapon, and to use it as a very strong weapon, because water is something quite important to our lives. Then the next one is on challenges before forest conservation in Sri Lanka. She made a point, the comparison, she wants to do a comparison between Sri Lanka and Australia. One interesting question was asked, why you use Australia as an example. That is quite important, that when you do the research, you have to make sure that you elaborate, because what they say is you have to compare apples with apples. Whether, as you know, Australia is a very developed country, and the system is well managed. In a system like that, passing laws, regulations, and the enforcement agencies are quite vigilant and effective. Whether we see the same situation in Sri Lanka is the next question. So you can make a point on that. When you elaborate your research paper, you can mention that. And also she gave some alarming statistics about logging in Sri Lanka. And also she mentioned way back 800 BC, we had certain types of laws during Mahinda period that Sri Lanka was in fact using conservation methods to protect the forestry. So that is also a very timely presentation. And then we came the robot situation. And everyone was interested in robots. As you can see from his presentation, he had generated a lot of interest about robot rights and the law. In fact, when I did some reading, in November 2017, United Nations Development Program has identified for the first time as an innovation champion for robots. And that is the first time United Nations has recognized non-human into their programs. And that itself shows the significance of the development of robots and their involvement in our lives. Quite interesting things. And I was thinking when the presentations were going, what about someone develop a robot? If there is a disabled robot, what will happen to that disabled robot? Who has the rights over that disabled robot? Can we terminate? And there are so many questions. And also another student asked a question about how the legal, the question of legal profession when it comes to robots. When it comes to artificial intelligence, I have seen, I have read, even the judgments can be created by artificial intelligence now. It is being tested now. Even in criminal cases, rape cases, all these cases where the countries have stored previous cases and using artificial intelligence, when a similar case comes, we may not need real judges to decide cases. I mean, you might think it is very scary situation, but I may not live that long to see these cases. I'm sure during your lifetime, you might be able to see it is happening. So the other question is, other important thing is you saw how many students like this area of robots. So that is a very good research topic if you really want to do. Not the other topics are not good, but they are also interesting, but this is also quite an interesting topic. And finally, we came to the paper on the application of the strong precautionary principle suggestions for Sri Lankan judiciary. And there was this question of using the principle of precautionary principle. She explained very well what is precautionary principle and whether we should use it in the strict sense. She mentioned that our judiciary is using it at the moment, but whether it should be done that way. According to the presenter, not only human beings, man or woman, there are other things also in this world. Not only they should survive, everyone should survive as well. But there was a very interesting question, what about Sri Lanka? In the developments at the moment in Sri Lanka, can we just use strict precautionary principle? What will happen to a country like Sri Lanka? When you think of other countries around the world, the developed countries, when they developed, when they came to this level, have they used precautionary principle to the maximum? Or did they use other methods? So we have to, there are so many things that we could learn from the history and also use it to our advantage. We cannot forget, we live in a small world, population is growing, and where are we going to go if the forests are, if there is deforestation, etc. So that is also a very interesting topic. And all these 4 topics are very, very important. I really like the students of KDU do more research. That is where you can do very well in your life. It is all about research. A university standing will go up if there is research. I strongly advise you that you do research and try to do publications in international journals. If you need any help, I'm sure there is a very good research team here. If you need any help, I'm more than happy to help you as well. So thank you very much. And that's all right. And next session is to hand over the certificates.
Thank you, Honorable Chairperson. I'd also like to thank all the presenters for sharing with us your immense knowledge. It was an amazing, absolutely fantastic session. So one more time, ladies and gentlemen, please give our presenters a round of applause. And thus, ladies and gentlemen, we would like to award the certificates to all the presenters of the session. And I respectfully invite the Honorable Chair, Dr. Athula Pathinayake, to do the honors. I kindly request all the paper presenters to come forward and accept the certificates. DMNS Dissanayake. D. Samaraweera. A. Edrisinghe and NKK Mudalige. Thank you, sir. If you could please remain on stage. As a token of our respect and appreciation, we would like to present these mementos to the Honorable Chairperson. I cordially invite the Dean, the Faculty of Law, Mr. Mangala Vijay Singha, to do the honors. Thank you very much, sirs. With that, we officially conclude the session. We hope to see you all at the next session. Thank you very much.